Good afternoon. My name is Bill Alford, and it's my privilege to chair today's meeting. And so we're delighted to welcome back to Harvard Law School. Welcome back to our law school, our graduate, Justice Dieter Grimm, a class of 1965, LLM from Harvard Law School. And his topic today is, unfortunately, as he and I were just discussing, a very timely one. Justice Grimm has an extraordinarily impressive career as a scholar, as a jurist, as an academic leader, and these days as a public intellectual as well. In addition to Harvard Law School, he studied at Freiburg, at the Free University of Berlin, and the University of Frankfurt, where he did his Habilitation. His long and distinguished academic career includes time at the Max Planck Institute for European Legal History in Frankfurt, the University of Bielefeld, Humboldt University, and 2 decades at the Wissenschaftskolleg in Berlin, where from 2001 to 2007, he also was the rector, the head of the institution. He's also been a visiting professor a number of times at Yale Law School and happily also at Harvard Law School. And he served from 1987 to 1999 as a justice of the Federal Constitutional Court of Germany, and was truly deserving of his international stature in terms of the decisions he was deeply involved with concerning issues of freedom of speech, freedom of assembly, privacy, data protection, and much, much, much more. He's a very prolific scholar in multiple languages. His books, just recent books, include Constitutionalism, Past, Present, and Future, from Oxford Press, Sovereignty, The Origin and Future of a Political Concept, from Columbia University Press, Human Dignity in Context from Hart, and much, much more. Lately, he has been writing about the kinds of issues and problems that he'll discuss today. Just a last quick comment for this lifetime of enormous distinction. He's won all kinds of awards. I'll just mention a handful, so as not to take up too much time. The Grand Cross of Merit with Star and Sash of the Order of Merit of the Federal Republic of Germany, honorary membership in the American Academy of Arts and Sciences, Commander-in-Chief of the Ordre National du Mérite of France, honorary degrees galore, the Lichtenberg Medal, membership in the Academia Europa, and much, much more. So Dieter, it's just a thrill to have you here. Thank you so much.
Thank you very much, Bill, for a very friendly welcome. It's always when I come back to this place hard to believe for me that my graduation lies more than 50 years back. This building did not exist. Of course, Harvard Law School was a little bit smaller than it is now. If I remember correctly, at this place was the dormitory for female students. Wyeth Hall, is that correct, more or less? Yeah. And you can also imagine that the number of female students was much smaller than it is today. Anyway, I'm happy to be at a place to which I owe very much. Toward the end of the 20th century, it looked as if constitutionalism had established itself definitely around the world. Many countries that had freed themselves from dictatorships, authoritarian regimes, racist regimes, military regimes, had turned to liberal democracy, had transformed themselves in liberal democracies. New constitutions were adopted, old constitutions were thoroughly rewritten, and I think also the willingness to take constitutions seriously had grown, and the indicator is that most of these countries, almost all of these new liberal democracies, established constitutional courts or supreme courts with the power of judicial review. Now, some 25 years later, the constitutional world looks different. Much of the optimism that one had after 1989, 1990 turned out as illusions. And a number of these constitutions that were established at that time take an illiberal turn, or they are openly disregarded. And this is my subject for today. But before turning to Supreme Courts or highest courts with the power of constitutional adjudication, I would like to ask, why constitutional adjudication in the first place? After all, there are no courts with power to judicial review if they haven't been established by politicians in the first place. I know there is an exception, that is the United States. Their politicians established a constitutional court, but not explicitly endowed it with the power of judicial review. However, I think that this idea, even if not explicitly mentioned in the Constitution, was not totally alien to America. There is the famous Federalist Paper number 78, where judicial review was clearly foreseen, so that Chief Justice Marshall didn't invent it out of the blue, but derived it from the Constitution as higher law, as a law that emanates from the people and therefore trumps a law that emanated from those who represent the people. But this is the exception. Very few other countries, but in the vast majority of countries, the establishment of judicial review is a deliberate decision of politicians. That's to say, constitutional adjudication is an act of self-limitation of politicians. Why do they do it? The father of the specialized constitutional review, which is dominant in Europe and different from the United States, Hans Kelsen, derived it from his theory of Stufenbau der Rechtsordnung, graduation of the legal order. Every legal norm, every legal act derives its legal force from an authorization by a higher norm, and is valid only if it remains within the framework of the authorization. And the question whether this is the case or not was for Kelsen a typical question for the judiciary. Legislative power derives its authority from the Constitution, so constitutional review is for him a logical consequence of constitutions. And he says, he goes even as far as to say that constitution without a specialized enforcement mechanism are almost like not having a constitution at all. However, Kelsen was not the constitution maker in Austria. He was the drafter of Austria's post-World War I, 1920 constitution. But of course, it was not Kelsen who adopted it. But apparently he convinced the politicians who adopted the constitution, so that Austria is the first country with a specialized constitutional court as opposed to a general Supreme Court with the power of judicial review. On a broader scale, judicial review was introduced only after World War II. And I think not by chance, by the three losers of World War II, Japan, Germany, Italy. All three cases are different. You may know that the Japanese constitution, post-World War II constitution, was written in Washington and translated into Japanese and sent to Tokyo for adoption. Italy, which had changed sides a few months before the end of World War II, was totally free to write its constitution. In Germany, the Allies, the three Western Allies, required the establishment of a West German state and required German politicians to draft a constitution for these West German states. The Germans were very unhappy about that because they were afraid this is cements the division of the country. But finally, they had to comply. So the German constitution is, so to say, commissioned by the Allies, but it is a truly German work. Now, the background of of both cases. Japan, by the way, has the General Supreme Court with constitutional review, and this court makes very rarely use of its power. As far as I can see, in almost 70 years of existence, 7 laws have been declared unconstitutional by the Japanese Supreme Court. Oh, the background with the 2 other examples, Germany and Italy, is of course the experience of the destruction of democratic constitutionalism, the dictatorship that followed, where all assets of constitutionalism were disregarded: limited government, rule of law, separation of power, fundamental rights. And there was a strong conviction in both countries, which I can best explain in 2 words: never again. And never again meant, on the one hand, never again the self-destruction of a democracy, and secondly, never again the total neglect of fundamental rights that happened in the times of the dictatorship. I think one cannot understand the German basic law if it is not seen as an endeavor to prevent the repetition of the end of Weimar and the rise of National Socialism once again. So there was a deep conviction that this time the constitution should matter, and there was also a deep conviction that for a constitution, in order to matter, some mechanism is necessary to enforce the constitution. So the establishment of a constitutional court in Germany, and the same is true for Italy, was not controversial. The great number of constitutional courts came later in time, but these are the forerunners. So when I say this, one can perhaps say this is an idealistic interpretation or an idealistic explanation of why politicians were willing to establish constitutional courts and thereby limit their own power. In more recent literature on judicial review, I find this idealistic explanation more and more criticized. Authors favor a more realistic approach. Rein Herschel is an important name for this tendency. Tom Ginsburg. Constitution makers and lawmakers are rational actors who, by establishing constitutional courts or courts with the power of judicial review, pursue their own interests in securing their predominance in the political system, even if they should lose their majority in a future election. So constitutional review is, with these authors, regarded as a hegemonic project. The permanence of the judiciary, the long tenure of judges that extends over several legislative periods, makes constitutional courts an attractive tool in preventing the opposition from making widespread changes in the program of those who are in power. And as a matter of fact, we will find in history countries where these motives may have been decisive for the establishment of constitutional courts. I think France can serve as an example. Turkey can certainly serve as an example. But in my view, rational choice doesn't explain everything. It is not true, in my view, that political actors only think strategically and are exclusively motivated by personal interests or by institutional self-interests. I think ideas and principles play a role, and particularly after a fundamental break with a past regime, as we have seen in the cases of Italy and Germany. A very good example is South Africa, which established a very important constitutional court. And I think President Mandela is a very good example that the idealistic interpretation is not completely false. Mandela lost a very important case in the Constitutional Court and went public on TV and said, this is what we have the court for. So if we acted unconstitutional, then they have to tell us and we will comply. Whether this is still true for the leaders of South Africa today is another question. And I think what realists don't take into account is that constitutional making is often not a dictate of a majority, but a consensus or a compromise between majority and minority. And then it is, of course, a good idea to think of the necessity of an umpire if situations change. Finally, I would like to say that the decision in favor of constitutional courts sometimes is pure imitation. And I think this is a case for a number of countries, former socialist countries, mostly in Eastern Europe. These were countries whose most important aim was to be reintegrated into the Western world and to copy Western constitutionalism, and constitutional courts seemed as an integral part of constitutionalism. So this may be an explanation for other types. Okay, conflicts between the political branches of government and constitutional courts can occur in each constellation. Constitutions impose constraints on politics, and constitutional courts enforce these constraints. So the possibility of a conflict between the political branches and the court is inbuilt in the system. This is not the problem. Conflicts are natural. The problem is when the political branches put pressure on the courts if they are afraid that the courts would decide in a way that doesn't please them. I think that conflicts are perhaps least likely in the hegemonic setting, the realist explanation. As long as the original majority remains in place, then it has nothing to fear from a like-minded court. But the fact that the political rivals agreed in the founding moment on judicial review does not immunize these courts against political pressures. Jurisprudence may take an unexpected turn. Politics may face unexpected challenges. The court appears as an obstacle against pursuing the common good as understood by majority parties. So all this may happen. And the likelihood of conflict grows, of course, when the founders leave the place, when the heroic times of a new country are over, reconstruction time is over, and politics as usual take place. Then the court is no longer felt as self-imposed, but it's felt as an external constraint. And this is especially so if a country finds itself in a deep crisis, whose solution requires unorthodox means, and government meets a hostile court. And this is the case, or was the case, in the first example that I would like to briefly treat, and this example is for all of you quite familiar. This is the United States in the Great Depression after 1992. Great Depression at a point at which President Hoover had just announced the end of poverty. So you can see how unforeseeable this deep crisis was, and Hoover, being convinced that the golden age would begin, had no means to handle the problem. Roosevelt had an answer, that was the New Deal. He won the election of 1932 and took over the presidency in 1933 and immediately issued a series of laws in order to regulate the economy. But one after the other was declared unconstitutional by a Supreme Court that firmly adhered to the Lochner jurisprudence, that's to say, insisted on liberty of contract, regardless of what was the object or the circumstances or the consequences of these contracts. So the question for Roosevelt was how to get around this obstacle. The answer depended, of course, on where the source of the problem lay. And the question that the Roosevelt administration asked itself at that time was, is the source of the problem the Constitution, the text of the Constitution? Then the solution would have been an amendment. Or is the source of the problem the interpretation of the Constitution? Then the reform would have to go to the court and to the judges. Historians have counted, surprising to me, have counted in this time 102 draft laws and 66 motions to amend the Constitution in order to solve that problem, all without success. Roosevelt waited. He waited for the second election, 1936, and this election ended with a tremendous victory. If I'm correct, Frank, only 2 states, I think, voted against Roosevelt. And now Roosevelt announced his court-packing plan, that's to say, his plan to add new judges to the Supreme Court that would then give the government a majority in the court. He did it in the following way. The plan would have given him the right to appoint a new justice for every judge or justice who reached or was over age of 70 but was not willing to step down. And this was true for 6 out of the 9 justices. That's to say, it would have immediately given him the possibility of appointing 6 new judges, which meant that the Supreme Court would have had 15 justices. Now, in spite of the vast majority that Roosevelt had in Congress, the plan met a lot of protest. Not only with the opposition, but also in Roosevelt's party. And the president was denounced even as acting like Hitler, acting like Stalin, acting like Mussolini. The final vote was never taken. In March 1937, Justice Roberts switched sides, West Coast Hotel, everybody knows this decision, and from now on voted with the critiques of Lochner. And this further diminished the support for the court-packing plan. In the Senate Judicial Committee, it was rejected. Shortly after that, Justice Van Deventer resigned, and therewith Roosevelt's court-packing plan was dead. But in the end, Roosevelt, again, if I don't miss anything, Roosevelt was the American president who in the end appointed the highest number of justices to the Supreme Court. Thank you very much, very kind. Yes. Namely 8. So he was free from all sorrows. So far the American example, but I will come back to it when I compare it with other examples. More or less at the same time, the Austrian Constitutional Court, to say the only constitutional court existing at that time, came under political pressure. Austria, after the collapse of the Habsburg Empire, was a parliamentary democracy, but the new political system was never fully accepted in the post-war years. It was a very rifted society, and that affected the functioning of the system. The political camps were irreconcilable. The differences were not only treated in parliament, but violently in the streets. The major political parties had paramilitary groups, and the call for a transformation of the parliamentary democracy in an authoritarian system increased. The right-wing Catholic Dollfuss government found an excuse to go ahead in March 1933. After a tumultuous debate in the Austrian parliament, the president of the parliament and the 2 vice presidents stepped down, and the government interpreted this as a self-dissolution of parliament. Attempts of the parliamentarians to assemble were prevented by police force by the government. The government continued to rule. It ruled by decree, and derived its authority from a wartime emergency law, 1917, that gave the executive the power to take the necessary measures to reconstruct the economy and to guarantee the food supply for the population. The measures that were now taken under this authorization were clearly not covered by the authorization, and so the Social Democratic Vienna government challenged these decrees before the Austrian Constitutional Court. And nobody doubted that they would all be declared unconstitutional, null and void. So Austria found itself, for the American question, how to prevent the court from deciding against the government. The answer was different than the American answer. The answer was not to add judges to the court, but the answer was to eliminate judges from the court. This, of course, was much more difficult to reach in a way compatible with the Constitution. One could, of course, attempt to convince judges, sitting judges, to step down, but this would have been successful only with those judges who stemmed from Dollfuß's own party, and that was not sufficient to paralyze the court. So the government decided to amend the statute on the Constitutional Court, again based on this purely economic emergency power of law of 1917. The amendment is difficult to understand without knowledge of how the Austrian court was composed and appointed. It was elected by parliament, 6 members upon proposition of the government, to say the cabinet, 3 members upon proposal of the upper house of parliament, 3 upon proposal of the lower house of parliament. Now, the amendment read as follows: judges elected upon the proposal of the 2 houses of parliament can only sit in court when all members appointed in this way are present. The argument was otherwise the balance of the parties in the court would be distorted. As I said, a little bit difficult to understand what was achieved through this amendment. If the government convinced only 1 judge who was appointed by parliament to resign, then none of the judges appointed by parliament would have been allowed to sit. So only the 6 judges appointed by, proposed by the government would form the court. This, of course, would have been enough to secure a court that would not disturb government plans. Now, when the Vienna Appeal that I mentioned was ready for decision, the president of the Constitutional Court complied with the amended law and invited only the 6 judges that had been appointed upon proposal of the government. But this entailed another question: is now the quorum for making decisions reached or not? This depended on the constitutionality of the amendment, and the court decided we are unable to decide this question because we are only 6, and in order to decide this question, there have to be more. From that moment on, the Austrian government had a free hand. The Constitutional Court was totally abolished. The new constitution transferred Austria in an authoritarian corporate state before it was then later on, a few years later on, overtaken by Hitler. So not much more is to be said about the first half of the 20th century because there were not so many courts with the power of constitutional adjudication. But these 2 early examples, I think, reveal already some patterns that repeat themselves over and over again. I briefly analyze the 2 examples by distinguishing between the situation out of which the pressure on courts arose, the goal, the means, and the outcome. The US situation is paradigmatic. a political party wins an election, maybe with an overwhelming victory, wants to implement its program, and the court stands in the way. So the goal is to get the legislature, legislative program through the court, and the non-reproachable way would, of course, a constitutional amendment. But if a constitutional amendment is not available, and in America it's practically not available, then what to do then? The next answer was to create a government-friendly court by packing. Was that constitutional? Not openly unconstitutional, I take it, because the Constitution doesn't fix the number of Supreme Court justices, and it was not always 9. They started with 5, I think. The life tenure was not affected by the CourtPacking Plan, but if we look beyond these formalities and look to the function of the court as a guardian of the constitutional law vis-à-vis the government, then things may become more problematic. The question remains open, as the CourtPacking Plan was not implemented, and the chances that it would have been implemented, even without the shift of Justice Roberts, are rather low. There was a lot of media opposition. There was opposition within the political system, even in Roosevelt's own party. That's to say, the court as an institution had a considerable number of social and political support, and this will be interesting when we come to other courts. The Austrian situation is different. No landslide victory of a political party. The government created the situation by paralyzing parliament and ruling by decree in a constitutionally doubtful way. And like in the United States, again, the court stood in the way. The goal was different from the US. The goal went beyond getting a friendly court. The goal, or the paralyzation of the court, was only a necessary step on the way to transform the political system from a democracy into an authoritarian system. And the means was eliminating the judges, so to say, negative sort of court packing, not adding judges, but taking them out. So, in addition, an amendment of the rules on the work of the Constitutional Court. And so we have here already the two mostly used means when it comes to eliminate or to tame or to paralyze courts. The one is court packing, and the other one is court curbing. Did the Austrian Constitutional Court, where the goal was much more far-reaching, as I said, than in America, did the Austrian Constitutional Court have a chance to survive? The preliminary question whether the amendments of the statute were constitutional, the court could have decided that by applying the amendment rules. It decided it by applying the amended rules of the Constitutional Court statute. If we pause for a moment, is that compelling, that the court felt compelled to apply the new rules to review the constitutionality of these rules? I think it's not compelling. The way the court shows, the object of review and the standards for review were identical. That's to say, this is a logical impossibility. And we will come back to that problem when we reach the Polish example, where the same question had to be decided. Let's assume the court had acted in a different way and had declared the amendments unconstitutional, and then, based on that, also declared all these decree laws unconstitutional. Would that have helped the court? Very difficult to say. The Austrian government was evidently interested in having everything looking constitutional. of that, if that would have helped the court over this deep crisis or not, is difficult to say. The most important difference with regard to the US case is perhaps that there was not much resistance from the side of society, certainly not from the political system. The only act of opposition to the plans that I've seen was a letter of some professors of public law that the measures were unconstitutional. So the support that the US Supreme Court in the court-packing era of Roosevelt saw was absolutely lacking in Austria. After World War II, we have more examples, and because there are more constitutional courts, of course, and there's also a new pattern, and the new pattern is Russia, where the Constitutional Court that was established after the end of the Soviet Union, in a situation of uncertainty about the fate of the political system, existed. Russia is the paradigmatic case for such a situation, a court acting in a situation where it is not clear what will become of the post-Soviet system. There was a new constitution, but the constitution was not yet firmly established, and it remained rather undecided between parliamentary democracy or presidential democracy. Behind parliamentary democracy were the old communist elites. Behind presidential democracy were the reformers. This Russian court had ample powers, surprisingly ample powers. The court could act on its own initiative, didn't have to wait for a case brought to him. The court had the right to be heard in parliament. The president could at any time appear in parliament and speak. And the president of that time, Zorkin, I think misjudged the power and interfered actively in this conflict with the idea that the court would be finally the umpire who decided these questions. This ended up in a bad way for the first Russian constitutional court. This was not a struggle within the framework of a constitution, but it was a struggle about the future power structure, and this is not a time for judges. So Yeltsin solved this conflict with force. The tanks of the army decided, not the court decided. The court was suspended. A new constitution was adopted in 1993, but again with a constitutional court. Even the members of the old constitutional court were reappointed, but a number of other new judges added to the court. The Russian court had learned the lesson and has learned the lesson still up to date. From that moment on, it refrained from taking decisions that would not please the government, and it seeks a low-profile role in securing fundamental rights in, how should I say, less conspicuous cases. This is up to now the situation in Russia. What we can observe today, and now I come to the present time, reminds of the US situation, but of the Austrian goals and means, yet different from first half of the 20th century in the name of democracy. And it happens in a number of countries, and among these countries are even member states of the European Union. I'm talking about Hungary and Poland, countries with strong constitutional courts and constitutional courts that were very successful in the period of transition. So the situation is that a former opposition party wins a majority in free elections. In Hungary, it is the Fidesz party. The Fidesz party in the 2010 election wins 53% of the votes, and this translates, because of the election laws of Hungary, in a two-thirds majority. In Poland, the Law and Justice Party, in the Polish abbreviation is the Peace Party, in the election of 2015 gains 36% of the votes, and this translates into an absolute majority. So the difference from the US is not the problem that certain legislative acts fail in the Constitutional Court. Rather, the existence as such of an institution with the power to annul majority decisions is what bothers the new rulers. And also other institutions that could make the life for a government difficult, independent judiciary in general, independent media, etc., come under attack. The goal is, like Austria, a transformation of the democratic system into a more or less authoritarian system, and the constitutional courts in both countries are the first targets. They have to be eliminated before the rest can be done. The ways and means differ in both countries, and the reason is the different result of the elections. Fidesz party has a 2/3 majority, that's to say, a sufficient majority to establish its goals by way of amending the constitution, so on the constitutional level. The Polish Peace Party has an absolute majority, but no majority sufficient to amend the constitution. That's to say, they are limited to changes that can be enacted by way of legislation, and legislation is subject to judicial review. Now, a short look to Hungary and then to Poland, and this is the end of my considerations. Hungary lived very long formally under the old communist constitution. Hungary did not enact immediately after 89-90 a new constitution, but the old communist constitution was heavily amended. The aim of the Fidesz party was a new constitution, but there was one obstacle to a new constitution. The previous parliament, where Fidesz was still in the opposition, had enacted a constitutional amendment saying that if a new constitution should be established, the rules for constitution making have to be adopted previously with a 4/5 majority. So Fidesz didn't have a 4/5 majority, so the first act of the government was to enact a constitutional amendment that eliminated the constitutional amendment that provided for a 4/5 majority. So then, with a 2/3 majority, everything could be done. The way was free to a new constitution, but independently. And before the new constitution was enacted, the statute of the Constitutional Court was amended, because still, even without the 4/5 rule, the Constitutional Court stood in its way. One point was the appointment of judges. Before these amendments, the political parties nominated the candidates for the 11 positions, but only a plurality of parties could make propositions. That's to say, no single party always had to be a party coalition. And the parliament then elected with a 2/3 majority. Now, the rule was that first of all, the number of judges was raised from 11 to 15, and the nomination rights were transferred from the political parties to a parliamentary committee that was composed according to the proportionate division of the seats in parliament. That's to say, in this committee, Fidesz had a 2/3 majority and could elect it. Well, was the only political force that could make a successful proposition and had the power to elect these judges. The judges in Young Hungary are no longer irremovable. They can be dismissed if they lead an unworthy life, whatever that means. The changes gave the Fidesz party the immediate chance to appoint 4 new judges. But 4 new judges were not yet sufficient to secure a majority for the Fidesz party in the court. So the court declared a number of laws of the new parliament unconstitutional. and it reviewed the constitutional amendments as to their constitutionality. It adopted the idea that also constitutional amendments can be unconstitutional. The laws that the court declared unconstitutional were the next day reenacted, but now by way of a constitutional amendment. Judicial review of amendments was limited to the formal question, is the procedure correct, but not to the substantive question. Laws with financial implications were exempted completely from judicial review. If a judgment of the Constitutional Court imposed payments on the government or had entailed financial consequences for the government was entitled to levy extra taxes in order to be able to fulfill these obligations. And then a new constitution was adopted, took force in 2012. And with this new constitution, it was decreed that all previous judgments of the Constitutional Court are null and void. The new court is not allowed to refer to any of the judgments that the court took in former times. A few more vacancies could be filled, and we have now a situation where the Hungarian court is no longer a threat to the Fidesz government. And this allowed the Fidesz government to take some of the amendments to the statute of the Constitutional Court back, which shows us that court packing and court curbing are somehow like converging pipes. If you have been successful in packing the court, curbing is no longer that necessary. If you are successful in curbing the court, packing is no longer that necessary. Short view of Poland. The ambition of the new ruling party in Poland is similar to the ambition of the Fidesz party, but it's more difficult to realize. The Polish party does not dispose of the constitution. It is limited to ordinary lawmaking. And the first step in a long battle that developed in Poland was done by the old majority. Now, the now opposition, the old majority lost the presidential election in Poland in 2015. The candidate of the Peace Party was elected. And so the that time ruling party was afraid that they would also lose the parliamentary election that followed a few months later. So what they did was, in their last session before the old parliament went out of office, they appointed 5 justices to the Polish Constitutional Court. 3, and this is now important, 3 for vacant positions, but 2 for positions that would only be vacant after the end of this parliament's term, to say under the new parliament. These judges were called the October judges. This, of course, fits into Herschel's picture of the hegemonic project, like Hungary. But of course, we are not in the stage of constitution making here in Poland. The president refused to take the oath of all five judges appointed by the old parliament. The new parliament challenged the election of the October judges and amended the statute on the Constitutional Court, among others terminating the offices of the president and of the vice presidents. The opposition challenged the amendments. The court and the parliament declared the election of the 5 October justices void, elected 5 new ones. The president took the oath of these 5 new ones at 1:30 in the morning, so they are called the midnight judges. The Constitutional Court decided, out of these 5 October justices by the old parliament, 3 are elected correctly because the seats were vacant. 2 are unconstitutional because at that time the seats were not yet vacant. And it declared the revised statute on the Constitutional Court partly unconstitutional. The government refused to publish the court decisions. And in order to take force according to Polish law, they have to be published, and not the court publishes its decisions and judgments, but the government publishes them. So the government refused to publish and enacted a new statute. And this is interesting. All cases have to be decided by the full parliament. European constitutional courts usually divide the cases in cases for the full bench and in cases in a simplified procedure for a smaller number of cases. So all cases have to be decided by the full bench. A quorum is necessary of 13 judges out of 15 have to be present. If the court wants to declare something unconstitutional, this requires a 2/3 majority. Cases have to be decided in the order of their arrival. Parliament can end the offices of individual justices. So the result is a paralyzation of the Constitutional Court. All of these measures, you will easily see what it means. No division of labor if the court can only sit in full bench. That's to say a lot less of work can be done. Quorum 13 or 15, if the government can convince 2 judges to be ill, then nothing can be done at all. A decision requires a 2/3 majority. Cases have to be decided in order of their arrival. That's to say all new cases challenging the constitutionality of government acts are at the end of the list, and it can take years before they may be decided. The Constitutional Court, still in place, reviewed these laws, and now we have again the Austrian question. Do I review the amendments to the procedural rules of the Constitutional Court according to the old rules or according to the new rules? And this makes a big difference, as we have seen from Austria. So the Polish court did not take the Austrian way. The Polish court reviewed the new laws according to the old abolished laws and came to the result that the new laws were unconstitutional. Again, the government didn't publish this decision, and by the mid of 2017, so a year to now, the Peace Party has a safe majority in the constitutional courts. A very brief remark to the end. I'm anyway too long. I see it. I don't think that judicial review is indispensable of democracy. I can imagine a democratic system without judicial review, and we have examples for that. Nor do I think that judicial review is irreconcilable with democracy. I also think that the conditions for constitutional adjudication can be changed if the provisions are in a constitution, then by amendment. If they are in a statute, then by ordinary law. Judicial review does not antedate the Constitution. It is a creature of the Constitution. But I think there are limits. If the Constitution establishes constitutional review, amendments or laws that prevent the court from exercising its function are unconstitutional. What matters, I think, apart from that, is the motive behind this. And the purposes of the reforms are alike in Hungary and Poland. They are part of the backsliding of liberal democracy that we can observe not only in these 2 countries, but in a number of countries in Europe. The establishment of, and this is probably new compared to older times, the establishment of an authoritarian government is justified in the name of democracy, yet it is a concept of democracy that is alien to the achievement of constitutionalism. It's a concept of democracy where democracy is identified with majority rule, and the majority again is identified with the people. It's to see declaring an act of parliament null and void then means obstruction of the will of the people. And this is exactly how the 2 parties in Poland and in Hungary argue. The people, in turn, is regarded as homogeneous, capable of having a uniform will. That's to say, minorities in this understanding, place themselves outside the people. They are enemies, and they may be silenced or eliminated. This is the situation there, and what is particularly troublesome is that it is a situation that appears in the middle of the European Union, and the European Union is absolutely unprepared for these measures and lacks effective means to deal with those countries that slide away from the goals of the European Union. But this is a topic for another lecture, for which now the time has elapsed. Thank you very much.
Thank you so much, Dieter. I think we have the room for a bit yet, Sarah. So those students who need to go to class, of course, should, but perhaps if you're willing, could take a few questions.
Yeah, of course.
So please.
Thank you so much. Thank you. Thank you so much, Professor. What appears from your lecture is that there's a pattern here where first a political majority wins the elections, and then their interests don't align with the Constitutional Court, and then there's a back and forth sometimes between those two branches of government, and then one of the branches prevails over the other. I'm wondering whether what parameters or what factors in to the end results, like in the American case that you described, the executive prevails. And in the other cases, it seems that the executive prevails too, but the sort of the defense mechanisms of the judiciary differs from country to country. Like Poland seems to me, from your description, to be more sort of resistant towards the political branch. And I wonder what affects that. I mean, is it because of how the court is composed? Is it because of how the court perceives itself? Like what factors, what parameters are at play there?
In general, I think, my examples are too small to form a reliable theory. One would have to include many more examples, and there are more than those I selected. But I think one distinction can be made already on the basis of these examples. It makes a fundamental difference whether the conflict arises within the constitutional system and without the attempt to fundamentally change the system. My impression is that under these conditions, where no system change is aimed at, courts have a better chance to survive. Whereas in systems where the goal is a system change, courts have a less good chance. The question of who is the opponent that you have, is it more the executive, is it more the parliament, doesn't play a big role in parliamentary systems, where the government is elected by parliament and is, so to say, the leader of the political forces that are in power. So it doesn't really matter who acts, whether parliament acts or the government acts. And the third element that I would like to mention is to what extent is there support for the institution of a constitutional court? That's to say, not only for this or that judgment, there will always be criticism, but to what extent is there, can support be mobilized? And what we can see in Austria, in Poland and Hungary is that not sufficient support can be mobilized for a constitutional court. And this shows me that we were too optimistic in 1989, 1990, insofar as the success conditions of the new system were concerned. I think what comes about clearer now than it was 30 years ago is that for constitutional courts, even more than for parliaments or governments, there is an extra legal conditions, extra legal circumstances. The context, the non-legal context, matters a lot. And within the non-legal context, The question matters, is this a society that has already accustomed itself to the rule of law, to have judges deciding important questions, or has that not taken roots? And I think this is the case in a number of the former socialist countries where these ideas have not yet taken roots. Otherwise, the court would at least find more support, which would at the same time make it more costly for governments to push their measures through. This is an attempt of an answer, yeah? But more answers would need more examples. Bill, you do that, yeah? Okay, yeah.
Thanks a lot for the presentation, very interesting. I was wondering if you could perhaps elaborate on a more theoretical theme, this notion of sort of democracy on the one hand and constitutionalism on the other. And I mean, I guess you were sort of pointing at perhaps what your view of that is at the end of your remarks here, where you were sort of outlining this sort of very narrow picture of democracy equated with majority decision-making. And this seems to neglect this other component, the constitutional component, which might be a prerequisite of it. And I'm wondering if you think that even under a more inclusive picture, there's still a tension between the two elements, or whether they are in sort of complete harmony, as perhaps Dworkin would have suggested.
No, they are certainly not in harmony. I think I said at one point that when we have constitutional adjudication, the conflict is inbuilt because governments have programs, have platforms, they want to implement them, and the political decision-making process is not like the juridical decision-making process. In the first place, the question is asked, what do we want to achieve? Do we find support for that? Do we have the finances? Is the means that we take an effective means? And then when all this has been answered into the affirmative, then in a constitutionally minded government, maybe, hopefully, the question will be asked, and is it constitutional or not? Is it permitted or not? And my experience shows that this last question is what we politically think is necessary to be done, is also permitted, is seriously asked only if there is an enforcement mechanism behind it. So without constitutional review, this last question loses importance or is not asked at all. So there is certainly a tension between democracy and constitutional adjudication. There's not harmony. But what I wanted to say, of course, I wanted to position myself against a number of very respectable American writers who say take the Constitution away from the judges. Constitutional adjudication is not democratic. This is not my opinion, because I think that the Constitution that is adjudicated is an act attributable to the people, and this is mostly left out when it comes to it. But on the other hand, I would also say that Kelsen, who says not having a constitutional court is almost like not having a constitution at all, is also not true. Because I have examples of very few happy countries in the world where the constitution is observed and taken seriously without an enforcement mechanism. I think the Netherlands are examples, the Scandinavian states are examples, UK is an example, but I don't know of many more.
Time maybe for one or two more questions.
Thank you. Very interesting talk. If we take the thesis that the sovereign is the populace and the sovereign can change constitutions, it seems that the Constitutional Court is one more component in this tension between legislature and inertia. So we have the bicameral system, and the upper house, which exists in Britain, creates the inertia for safety. Then the problem philosophically seems to me, and I would appreciate your comment, to be more complicated because the Constitution is not God-given. It is decided by the people. So it's part of democracy in this case.
This is certainly true. I think the big and important step that the Americans did in 1776 and the following years was to say, in contrast to the UK, not Parliament is sovereign, but the people are sovereign. This is also my conviction, my democratic conviction, that the people should be sovereign, whatever that means practically, but it means certainly then that the Constitution is attributed to the people, which means that the people is free to alter it when they act as the people, as constituent power. When the people act in their power as empowered by the Constitution, for instance, if the Constitution provides for a referendum, they are not the people in their capacity as constituent power, but they are people in their capacity as constituted power, and that they can only decide within the realm of the Constitution. Now, the Constitutional Court, if the system functions well, enforces the will of the people, constituent power, against the representatives of the people, constituted power. So on this theoretical basis, I have no problem. I have no problem because I uphold very firmly that the people can at any time go back into their status as constituent power and change the whole. This is not accepted by everybody. There are people who say that a new constitution can only be made on the basis and by the authorization of the old constitution. This is a denial of the sovereignty of the people that can in any time be enacted. So I think we'll conceive it like that. I don't get into theoretical problems, but if, of course, I have a democratic concept like these parties in Poland and Hungary, then things look quite different, because then the majority is the people.
Okay, last question.
Thank you, and thank you for the talk. So one of the interesting things in these developments is that oftentimes the changes made to these courts are in some sense small, like taken in many incremental steps, often legal in the sense of being within the realms of what is permissible of, you know, changing small rules there and small rules here, and perhaps have a justification of some sort that sounds close to plausible. So in the moment of these constitutional courts receiving these questions, it seems like they have to decide not only when have lines been crossed for those sort of things, and they also might have to answer the question, is there a, as you put it, is there a systematic change going on here? That might also be, you know, hard to see in the moment and contentious. I mean, some people describe the Roosevelt not as a business as usual constitutionalism, but like a constitutional moment where there was a systematic shift. Do you have a good idea of how you answer these questions?
I think that I fully agree with what you say, and I think what you just described explains the difficulty that, for instance, the European Union has to react to these things. The defense, the European Union intervened in the beginning softly, now more seriously. The defense on the Polish side as well as on the Hungarian side was that they could name for every single measure an example in some other member state of the European Union. The cumulation existed nowhere. And if a government with the idea of transforming the system is wise enough, it puts a little time between the individual small measures, and this makes it difficult. It's also difficult, I mentioned that at one point, the motive behind is decisive, but it's not so clear to discover, is this really the intention of a system change, or is it pushing the system a little bit more to the right or a little bit more to the left? What all are interested in is it should look legal. This gives certain hopes, because not everything, I think, can be tailored in that way that it looks legal. But again, this would require a population that recognizes that and makes use of these possibilities. But I think you are totally right. It's accumulation of, in itself, small measures, each of which alone could stand, probably. But the accumulation and the intention to use it as an instrument to transform the system is what makes the difference. Now, the European Union, as I said, is not prepared. The European Union says what a member state, which principles a member state must comply with, and it doesn't say much what happens when the member states doesn't do it. Then the European Union can take, more or less, this is the language, the necessary measures up to depriving a country from its vote in the Council. This is consequently regarded as the severest means. And the discussion that we now have in the European Union is depriving these countries of funds that they get, also a necessary means in degree below depriving it of the voting rights. Because taking money away, all these countries get a lot of a tremendous amount of money, would be the only means that I think could bring the development to a halt. A very, very important role plays the Venice Commission. Many of you will know what it is. We don't have the time that I elaborate, but the Venice Commission has played a very important role in pointing to the dangers, but it can only give advice, it cannot take any measures.
Thank you so much, Justice Grimm.